Judgment in the appeal, Stott and Thomas Cook Tour Operators Limited.
Lady Hale will explain the judgment of the court.
Mr Stott is paralysed from the shoulders down, a permanent wheelchair user and doubly incontinent. When travelling by air, he depends upon his wife to help him to eat, to change his sitting position, and to deal with his catheter bag. To do this properly and discreetly, she needs to sit beside him. Mr. and Mrs. Stott booked a holiday in Greece with Thomas Cook, a well-known tour operator with its own airline. They were assured that they would be seated together on the journeys. But when they came to take the flight home, they were not allocated seats together. His wife therefore had to sit separately from Mr. Stott and to get up to help him with his needs. Mr. Stott was extremely embarrassed and humiliated by the situation. With the help of the Equality and Human Rights Commission, he brought a claim under the Civil Aviation, Access to Air Travel for Disabled Persons and Persons with Reduced Mobility, Regulations 2007. These regulations implement a European Union regulation on the same subject. The judge found that the airline were indeed in breach of those regulations. He would have awarded Mr. Stott £2,500 damages for the injury to his feelings. But the judge held that he was prevented from doing so because of the Montreal Convention for the Unification of Certain Rules for International Carriage by Air. This convention gives air passengers certain easily enforceable rights to compensation. But in return, it limits the harm which may be compensated to death or bodily injury, and also the amounts of compensation payable. More importantly, it provides that, in the carriage of passengers, any action for damages can only be brought subject to the conditions and limits of liability set out in the Convention. The Court of Appeal agreed with the judge that the Convention prevented him from awarding damages to Mr. Stott. Mr. Stott appealed to the Supreme Court, arguing that the regulations were all about access to air travel for disabled people and not about accidents on board the aircraft. The airline had undoubtedly breached the regulations, and the regulations expressly allowed for the payment of damages. The Supreme Court's judgment is delivered by Lord Toulson, with whom the other justices agree. The court agrees that Mr. Stott had been very badly treated by Thomas Cook. He has suffered exactly the sort of embarrassment and humiliation that the regulations were designed to prevent. Unfortunately, however, the Montreal Convention applied to all personal injuries suffered on board the aircraft, and this was where the harm had been suffered. What mattered was the time and place of the injury and not the quality of the cause of action. So the appeal has to be dismissed. But there was much to be said for the argument that it is time for the Montreal Convention to be amended to take account of modern equality rights, including the rights of disabled people. And Mr. Stott has done us all a service by exposing an injustice to which the international community should be turning its attention.